An IRA and a 401k are both retirement accounts that offer the benefit of deferring income tax to the future. Typically, these accounts are marital assets to the extent they were created or contributed to during the marriage. Generally, three situations arise involving these types of retirement accounts. The first situation is that the account is created and contributed to during the marriage. In this situation, the entire account is marital property and can be divided between the parties by the judge. The second situation is when a spouse has the retirement account prior to the marriage and does not add to it during the marriage. In this situation, the entire account is not marital property and will not be divided between the parties by the judge. The third situation involved is when a spouse has the retirement account prior to the marriage and contributes to the account during the marriage. In this situation, only the portion of the account that was created during the marriage is considered marital property, which is subject to division by the court in the equitable distribution of all your assets and debts. Now, as an example, suppose that just prior to your marriage, you have an IRA with $50,000 in it. While married, you continue contributing to this same account. When you get divorced, there is now $75,000 in the account. In this situation, only the $25,000 difference is marital property, since it was the portion that was added to the account during the marriage. It's only that $25,000 that can be divided up amongst the parties. Often, each account is not divided. There's no requirement that each individual account be divided. It's just that the whole net to both sides is roughly equivalent. The spouses may still be left with roughly the same equivalent value in their retirement accounts, but this can sometimes be accomplished by making a single transfer from one account to the other instead of making multiple transfers.